Welcome to the silent verdict.
With Clara Monroe and Elias Gray. Ever signed on the dotted line for a car and then, well, found out the paper that really matters was missing?
Yeah, it's a scary thought, isn't it?
It really is. It actually happened to quite a few people in Ohio recently. It's a story that'll definitely make you think twice the next time you're handed the keys.
Absolutely. We're looking at a situation out of Butler County, Ohio, and it's fascinating in a troubling way. Imagine buying a car, maybe making payments, but never actually receiving the title.
The legal proof you own it.
Exactly. That's really the heart of a lawsuit filed by the Ohio Attorney General against a used car dealership. It's defunct now, but the story, well, we should dive into the details.
Right. We got a heads up from listeners about a WCPO News report on this. It details this lawsuit against a dealership in Monroe, Ohio, and its owner, too. The allegations are pretty stark.
Stark is a good word.
Yeah.
They reportedly sold numerous used vehicles without ever giving the buyers the legal titles.
So people paid their hard-earned money.
Yep. Paid the money, drove off the lot maybe, but we're basically left in this kind of legal gray zone. No proof of ownership.
Okay, so the lawsuit, it names both the dealership, I think it was on Lebanon Street, and the owner, personally.
That's right. Both are defendants. And the core accusation is that they failed to file the applications for certificates of title after they got the vehicles themselves.
Okay, so step one was miss.
Right. But here's the real kicker.
Yeah.
They then allegedly turned around and sold these vehicles anyway to customers without having valid titles ready to go.
Just think about the implications for those buyers. It's more than just an inconvenience.
Oh, way more. You can't properly register the car. Insurance gets really complicated.
Yeah.
It just throws your whole ownership into question.
And this wasn't just like a one-off paperwork mistake, was it? Sounds bigger.
Doesn't seem like it, no. According to the Ohio Attorney General's office, they've pointed to the financial fallout. There's something called the state's Title Defect Rescission Fund, or TDR fund.
Okay, what's that?
Well, this fund has apparently paid out, get this, $86,000.
Wow.
$86,000
Oh.
to consumers who bought cars from this specific dealership and ran into these title problems.
86 grand suggests this was, a fairly widespread issue for them. What makes a fund like that necessary in the first place? Is that common?
It suggests these kinds of title problems happen often enough that the state needed a mechanism to help consumers.
Yeah.
We probably circle back to that fund.
Okay. And adding another layer here, you said the dealership is defunct now?
Yeah, no longer operating. The report says the car lot is abandoned, just empty.
So it's like the business just vanished, but
Yeah.
the legal problems, they're still very much alive.
Indeed. The Ohio AG is going for a permanent injunction. That's a court order, basically aimed at stopping the dealership and the owner from ever operating as a car dealership in Ohio again.
Under any name.
Under any name, yeah.
Yeah.
That's the goal. It's a pretty decisive move, trying to lock them out of the industry in the state. But what else are they trying to prevent?
So a complete ban on selling cars in Ohio. But it doesn't stop just with the business entity, does it? They're going after the owner individually, too.
That's right. There's a second injunction they're seeking. This one specifically tries to prevent the owner from even applying for any motor vehicle dealer license in Ohio in the future.
So no loopholes.
Seems like that's the idea. It suggests the AG's office is worried this person might just try to pop up again, maybe under a different company name. It makes you wonder, how easy is it to just switch between different business licenses?
It sounds like they're trying to shut down every possible path for this individual, at least in the Ohio car market. And, okay, beyond stopping future business, there are penalties involved, too. Financial ones.
Oh, absolutely.
Yeah.
The lawsuit is seeking civil penalties of $25,000 per vehicle.
Per vehicle.
Per vehicle allegedly sold without a title. Now, think about that $86,000 paid out by the TDR fund. If each of those represents a car.
That could add up very, very quickly.
Could be substantial, yeah. Really makes you wonder what factors go into setting those penalty amounts. Is it just the number or the severity or...
You'd think, though, with such serious allegations, a big lawsuit, there'd be some kind of response from the dealership or the owner.
You would think. But the report indicates they haven't really been engaging. The lawsuit notes a lack of response. But here's a weird twist. Despite the dealership being defunct, lots abandoned, everything, Ohio's business search tool, like the Secretary of State's website, apparently still shows the owner holding an active license for this very dealership.
Wait, how does that work? How can a business be gone but the license is still active? That's confusing.
It's a major disconnect, isn't it? Like the official records haven't caught up with the reality on the ground. And it gets, well, a bit more complicated.
There's more.
Yeah, the report mentions the owner also seems to hold a license for another dealership. Different name, slightly different, but also reportedly active.
Uh-oh. So could that be a way, could they potentially still be operating or try to operate through that other license despite all this?
That's the concern, right? What kind of oversight is there to connect those dots and prevent that? It definitely raises questions.
So while one business is facing the music, maybe another door is still open, and the address for the defunct dealership seems like it had a bit of a history itself.
It does. The same address, the one on Lebanon Street, was also linked to other businesses, cleaning companies apparently.
Okay.
And interestingly, the license for one of those cleaning companies got canceled way back in 2015. Reason? Failure to renew it. So it maybe paints a picture of a business location with, let's say, some administrative challenges over the years.
Could that history suggest a broader pattern of maybe not keeping up with the paperwork side of things?
It's possible.
Yeah.
It definitely adds context. And it seems like consumers might have had some warning signs about this dealership too, right? Through the Better Business Bureau.
The BBB. Yeah, what did they have on them?
The dealership had an F rating. That's pretty much the lowest you can get.
An F. Why?
According to the BBB, it was because the dealership failed to respond to 6 consumer complaints filed against them. Just no response.
6 complaints they just ignored. Okay, an F rating is definitely a red flag for anyone looking them up.
Huge red flag.
Yeah.
But it's important for listeners to remember what the BBB is and isn't.
Right. They're a nonprofit. They try to help mediate disputes, but they don't have legal teeth, do they? They can't force a resolution like a court can.
Exactly. They gather info, track complaints, provide ratings, which is super useful for consumers doing their homework. But yeah, they lack the legal authority to enforce settlements or impose penalties like the AG can. So the F rating, a serious warning, but not a legal judgment itself.
Got it. So, okay, with all these pieces, let's maybe unpack the core legal issues here. What laws are actually being broken, allegedly?
Well, at the heart of it, you've got Ohio laws. Laws that first require dealerships to actually have the titles for the cars they're selling, have them in their possession.
Makes sense. You can't sell what you don't technically own or have the right to sell.
Precisely. And second, there are crucial regulations about filing the title applications within a specific time frame after a sale. The report mentioned a 40-day window in Ohio.
40 days to get the paperwork filed so the buyer gets their official title.
Right. And failing to meet that deadline, that just kicks off a chain reaction of legal problems for the buyer. It raises the question, what kind of problems can actually pop up if there's a delay?
40 days seems like, a reasonable amount of time. So what are the consequences if a dealership blows past that deadline? What happens to the buyer?
Well, think about it. If you, the buyer, don't get your title promptly, you can hit major roadblocks trying to register the vehicle with the state. Getting proper insurance can become a nightmare.
Right, because you can't prove you own it.
Exactly. And ultimately, you can't legally prove ownership. This could lead to fines if you're driving it, huge legal tangles if you ever try to sell that car later. It's just a massive amount of stress you shouldn't have to deal with. Makes you wonder, what protection do consumers even have when this happens?
Which brings us back to that title defect rescission fund, the TDR fund. We know it paid out $86,000 in this case. What's the thinking behind a fund like that?
Well, the report didn't go deep into the fund's mechanics, but just the fact that Ohio has this title defect rescission fund, it suggests the state recognized this is a potential problem area and wanted a way to protect consumers when title issues pop up because of a dealership.
So like a safety net.
Exactly. And it's highly likely funded by the dealerships themselves, maybe through fees or contributions. So the industry itself is sort of policing or insuring against this issue. Why would the industry support something like that, you think?
Maybe to maintain consumer confidence.
Yeah.
If people know there's some backup, they might feel safer buying from dealerships.
That could be part of it. It provides some recourse when things go wrong with titles. But let's talk bigger picture. What are the actual legal implications of selling a car when you don't have the valid title in hand?
Yeah. What does that mean legally?
Fundamentally, it's a breach of the sales contract. You're selling something you don't have the clear legal right to transfer ownership of.
So the buyer could sue the dealership directly.
Absolutely. On top is any action the Attorney General takes. And it almost certainly violates Ohio's consumer protection laws, too, the ones designed to stop unfair or deceptive business practices.
And that's where the Attorney General's power comes in, seeking those injunctions and those big civil penalties. That's about enforcing those consumer protection laws.
Precisely. The AG's office has that duty, that responsibility, to protect the public from unlawful business practices. Injunctions are a powerful tool. They stop the problematic behavior going forward. And the civil penalties, they act as a deterrent financially and hold the business accountable for the violations. What kind of message do you think penalties like that send out?
It's a pretty clear warning, I'd say, to other dealerships, that this kind of conduct is unacceptable and it's going to cost you, potentially, a lot. Now, the report mentioned something about bonding for dealerships. How does that fit in?
Right, bonding. Many states, Ohio included, require dealerships to get what's called a surety bond. You can think of it like a specific type of insurance policy, but for the consumer's benefit.
Okay, how does it protect the consumer?
It provides a financial guarantee.
Yeah.
If a dealership does something fraudulent or unethical, like, well, title fraud, consumers who are harmed can file a claim against that bond to recover their financial losses, up to the amount of the bond, of course. So it's another layer of potential protection for buyers.
Okay, so there are multiple safeguards, the law, the AG, the TDR fund, the bond requirement, at least on paper. So looking at the lawsuit itself, what are the main arguments the Attorney General is likely making? What's their core case?
The number one argument, no doubt, is that this dealership just plain violated Ohio law, selling cars without having the titles, failing to process the title transfers within that 40-day window.
Straightforward violation.
And that this directly caused financial harm. People paid for cars they didn't legally own and created huge legal headaches for consumers, which, in turn, led to those payouts from the TDR fund, costing the state, or rather the fund, money. It just, undermines the whole car buying process.
So they're arguing the dealership didn't just break the rules, they actively created significant problems and costs for customers and indirectly for the state or the fund.
Exactly. And beyond that, the AG is almost certainly arguing that this wasn't just a few isolated mistakes. The pattern of alleged behavior, the number of affected consumers suggested by the 86K payout, that demonstrates a pattern of misconduct.
Okay, a pattern. And why is establishing a pattern important?
Because that pattern strengthens the case for those permanent injunctions. They'd argue it shows this wasn't an accident and there's a risk this owner or business could do it again if not stopped completely. It's about preventing future harm to the public, preventing a repeat performance.
Right, stopping this from happening again, no matter the business name. And those big civil penalties, the $25,000 per car. That must tie back to the scale, right? The number of violations.
Precisely. That per-vehicle penalty underlines the Attorney General's belief that the scope here was significant. It justifies a substantial financial consequence, and it also sends that strong warning signal to the entire industry. Messing with titles have a hefty price tag.
Okay, so looking back at how this all unfolded, what were the key moments, the turning points that led us here to this lawsuit?
Well, the first critical point, probably invisible to the customers at the time, was when the dealership allegedly failed to get the titles sorted after they acquired the cars. That initial failure, that inaction, that set everything else in motion.
The starting point of the problem.
The second crucial point, the decision to actually sell those cars anyway, selling them to consumers without having the legal titles ready. That's when the direct harm to the buyers happened. What do you think might even prompt a dealership to skip that first step? Cash flow issues, sloppiness.
Hard to say. Could be many reasons, none of them good for the buyer. You can just imagine the eventual frustration, the legal mess for those buyers later on. So what happened next to bring it all to light?
The complaints. The accumulation of consumer complaints was definitely a major turning point. People realizing they had a problem, contacting authorities or the BBB.
So individual buyers speaking up.
Exactly. Those complaints likely triggered the Attorney General's investigation, which then uncovered the scale of it and ultimately led to filing this lawsuit. It really shows the power consumers have when they report problems.
That's a good reminder. Don't just suffer in silence. And then the dealership actually closing down, abandoning the lot. That feels like another significant moment in the timeline.
It does, yeah. It could suggest different things, couldn't it? Maybe an attempt to dodge accountability. Maybe the business just collapsed under the weight of it all. But then you have that weird detail about the owner apparently still holding active licenses.
Right, which complicates the vanishing act idea.
It does. And finally, that $86,000 payout from the title defect rescission fund. That's a concrete number, a clear turning point. showing the real, widespread financial impact of what was allegedly going on. It quantifies the damage.
So with all that on the table, the lawsuit is ongoing. What's the likely outcome? Or at least, what's the AG aiming for as a verdict?
Well, the lawsuit itself tells us what they want. Those permanent injunctions banning the owner and any associated business from selling cars in Ohio, and significant financial penalties. That's the specific outcome the Attorney General is seeking.
And their chances.
It probably hinges on the evidence they present and whether the dealership owner actually mounts a defense. Given the reported lack of response so far, well, that doesn't usually help the defense's case.
No, it certainly doesn't sound good for the dealership or the owner. And if the AG wins, gets those injunctions, the consequences could be severe, really barring them from the Ohio car business for good.
That's the goal, yes. If the injunctions are granted, it would effectively do that. And it sends that strong message, doesn't it, about how crucial title laws are and the need to protect consumers making these huge purchases.
Okay, so let's wrap this up. Bringing it all together from this deep dive, what's the #1 key takeaway for the listener hearing about this Ohio dealership situation?
For you listening to this, I think the absolute biggest takeaway is always, always, always verify the title status before you finalize buying any vehicle, especially maybe if you're dealing with smaller, independent dealerships where things might be less standardized.
Don't just assume the paperwork is fine. Ask questions.
Ask to see the physical title if possible. Understand exactly how and when the ownership transfer will happen. Don't feel rushed.
That is really key advice. And we saw that funds like Ohio's Title Defect Rescission Fund exist, which is good, a safety net. But you really don't want to have to rely on that, do you?
No. It's much, much better to do your homework upfront, your due diligence, and try to avoid the problem altogether. And remember, the BBB useful for checking complaint history, getting a feel for a business, but it's not the ultimate legal backstop.
Right. Their F rating was a warning but didn't stop the sales.
Exactly. And fundamentally, dealerships have a clear legal duty. They must provide you with a clear title for the vehicle you buy. Failing to do that isn't just bad service, it's a serious legal issue.
And it's somewhat reassuring, I guess, to see that authorities like the Ohio Attorney General do take action in these cases. It shows there is some recourse, some protection, even if it takes time.
Yes. While the situation itself is concerning, the response shows the system can work to hold dealerships accountable when they allegedly break these rules.
So, bottom line, next time you get that new car smell, just make absolutely sure you're actually holding the keys to real legal ownership, not just a temporary ride.
Definitely.